Did you know that putting the wrong things in your will can be a big mistake? I'm going to show you 8 things that people constantly put in their wills that shouldn't be there. Hi, this is Arizona Wills and Trusts attorney Richard Keet at www.KEYTLaw.com and 480-664-7478. If you are an Arizona resident, I want to prepare an estate plan with a revocable living trust that protects your most valuable assets, your loved ones. If you've done any of these, your wishes may not be satisfied, and your family could be in for a nasty surprise when you're gone. Look, I see this all the time. People think they're being thorough by cramming everything into their will. But here's the problem. Some things don't belong in a will, and putting them in can backfire big time. Whether you wrote your will or paid somebody a lot of money to write your will, these mistakes happen more often than you think. And mistake number 3, it could cost your loved ones a big part of their inheritance. Here are the 8 things you should never put in your will. Mistake number 1, funeral and burial instructions. Don't put "I want to be cremated" or "I want to be buried" in your will. Why? Because your family might bury or cremate you before seeing your will. Instead, tell your family what you want to happen, or better yet, put your wishes in a separate document you give to the appropriate people before you die. We give our estate plan clients a document called Postmortem Wishes, in which they can state what they want to happen after death and recommend that they give a copy of the document to the appropriate people. Mistake number 2, organ donation wishes. Congrats to you if you want to save lives donating your organs. Amazing. But don't say in your will that you want to donate your organs. By the time your will is read by your family days after your death, your organs are no longer viable for transplant. Register as an organ donor online, put it on your driver's license, and tell your family, but don't put organ donation language in your will. If you are an Arizona resident who wants to allow your organs to be donated, then you must add your name and information to the Donate Life AZ registry and have the donor printed on your driver's license or identification card. You may apply to be an organ donor online at azmvdnow.gov or go to any Arizona Motor Vehicle Division office. Mistake number 3, IRA and retirement account beneficiaries. This is huge. Your IRA might contain a lot of money, but if you write, "I leave my IRA to my son" in your will, it means nothing. Why? Because a will is not the place where you designate retirement plan beneficiaries. When you opened your IRA or retirement account, you signed a beneficiary form that stated who inherits the account when you die. Your beneficiary designation form submitted to the custodian or administrator of your account controls who gets funds in the account when you die, not your will. You must update your beneficiary designation form from time to time to make sure it always names the person or people you want to inherit the account. Mistake number 4, life support and medical decisions. If I'm brain dead and being kept alive by a machine, pull the plug doesn't belong in your will. Hospitals don't have your will. Hospitals need this information immediately when you're admitted, not weeks after you die. Use a living will or advance directive instead. That's what hospitals actually look for. We prepare a living will for our estate plan clients. Mistake number 5, assets that are in a trust. If you put your home in a trust to avoid probate, don't then write in your will, "I leave my house to Sarah." The trust controls who inherits assets in the trust, not your will. Your will only controls assets that remain in your individual name after you die. Mistake number 6, individual properties owned by your LLC. You can't leave specific rental properties through your will if they're owned by your LLC. If you have 7 properties in one LLC and want each to go to a different person, you can't do that through your will. Your LLCs should be owned by your trust, and the trust should say who gets various assets when you die. Mistake number 7, long personal explanations. Don't write a novel about why you're giving money to one child and not others. I'm leaving Emma $250,000 because she visits me every week and brings me McDonald's, while my other children only call once a month. This creates family drama and gives people ammunition to contest your will. Mistake number 8, life insurance and annuity beneficiaries. Just like IRAs and retirement plans, life insurance has its beneficiary designation forms. If your will says your grandson gets your $200,000 life insurance policy, but your life insurance beneficiary designation form you signed 10 years ago names someone else, that other person gets the money. The beneficiary form controls who gets the life insurance proceeds. Here's the key takeaway. Your will only controls assets that remain in your name after you die. Everything else, retirement accounts, life insurance, trust assets, jointly owned property, has its own rules and beneficiary forms. Don't try to control these assets through your will because it simply won't work. If you made any of these mistakes, don't panic, they're fixable. If you comment contents, I'll send you a link to my article that shows our fees and describes the 36 documents and services you will get if you hire us to draft your custom estate plan with a revocable living trust. To book a free office, phone, or Zoom video meeting to get answers to your estate plan questions and design your custom estate plan, go to KEYTLaw.com calendar. Thanks for watching. Richard Keat, 403. 5-star Google, Facebook, and Bird Eye reviews, direct phone, 480-664-7478, rkkeytlaw.com.